Management of law firms, the partner-associate and client law firm relationship. The Anglo-Saxon law firm is primarily run as a business and is thus essentially profit-driven. Central to any business's success is its relationship with its employees and its clients. In a law firm, this refers to as the relationship between both the firm's partners and its associates, and also the law firm and its clients. Law firms are run by their partners, and the primary means of measuring the success of a law firm is to look at the average annual income earned by partners. The amount of income earned by partners in a law firm is dependent on three basic factors. 1. The amount charged by partners in a firm. The better the reputation of a firm, the more its partners can charge. Second, the billing methodology employed by the firm. And third, the leverage ratio applied by the firm concerning its partners and associates. By leverage is meant the amount of associates working for each partner. The more associates that the partners in a firm have working for them, the more profit partners in that firm will make, on condition, of course, that there is enough work for each associate. A law firm with a lot of associates and few partners is said to be a highly leveraged firm. If there is not enough work, then the firm quickly becomes less profitable and can even go bankrupt if associates are not fired. This can lead to associates being laid off by law firms in times of economic downturn and less associates being hired. This can in turn cause a reduction in the partner-associate ratio, whereby the amount of partners in a firm can actually be greater than the amount of associates. This happens in particular to law firms that choose to make too many associates partner. This is also financially dangerous. Clearly, the more partners in a firm, the less profits to be distributed between them. Firms with too many partners, i.e. a top-heavy, low-leverage partnership structure, can easily experience financial difficulties, as it is not as easy to fire a partner as it is an associate. Now let's look at the question of billing and the financial relationship between a firm and its clients. As already mentioned, an Anglo-Saxon law firm is run as a business and thus exists to produce profit for its partners. This can lead to aggressive billing practices, and like any business, when there is an economic downturn, law firms are required to lower their fees and even change their billing model if they wish to hold on to their clients. It is not an exaggeration to say that billing is the financial lifeblood of a firm, and that a firm that does not apply the correct billing strategy can very quickly go bankrupt. In an Anglo-Saxon law firm, billing can take a number of different forms depending on the nature of the relationship with the client and the overall state of the economy. Lawyers can bill for the work they do in a number of different ways. Hourly billing. Hourly billing is considered the most profitable billing methodology used by law firms. Consequently, it is the most popular billing technique amongst lawyers, if not their clients. Flat rate billing. With flat rate billing, a fee is negotiated in advance for the work that is to be done. This billing technique is also referred to as charging fixed fees. Retainer fees. With retainer fees, a lawyer is paid a fixed amount to represent a client over a fixed period, whether any actual legal problems arise or not. Contingency fees. Contingency fees provide for a lawyer receiving, as payment for their work, a percentage part of the damages received by a client where an action has been successful. This is also referred to as payment on a no-win, no-fee basis, or as payment on a no-fee, no-foul basis. Contingency fees are often used by lawyers in personal injury litigation cases. This is probably because the amount of damages available can be considerable. Finally, a combination of the above. It is also possible to have a combination of the above billing methods. For example, a lawyer can receive an annual retainer and can then negotiate further payment subject to the complexity of the legal problems that arise. Let's take a closer look at the area of contingency fees. As we have seen, if a client is charged on a contingency fee basis, payment will only be due if the lawyer is successful. If the lawyer loses the action, the lawyer and not the client will have to pay the legal costs involved. On the positive side, contingency fees promote client benefit, as the client does not have to pay the costs of the action if he or she loses, and lawyer benefit, as the lawyer receives a percentage of the overall award made to a client if the case is successful. The negative aspect of contingency fees is that if a case is successful, the client receives less money for the loss he or she has actually suffered. However, if the case is unsuccessful, the lawyer receives no money for the work they have done. Due to the fact that bringing a legal action in the common law world can be extremely expensive, i.e. legal costs can be prohibitive, contingency fees are viewed as a mechanism allowing people with limited funds better access to justice. This is why Anglo-Saxon regulatory authorities have championed their use. However, lawyers can also benefit greatly from using contingency fees, as the amount of money a lawyer may receive in fees can potentially run to millions. This is linked to 1. The size of awards in common law jurisdictions. It is believed that the amount of damages available to plaintiffs is increased when the decision is being taken by a jury, and 2. The use of punitive damages in common law jurisdictions, whereby certain reprehensible behaviour by a defendant can be punished by increasing the amount of damages awarded to the plaintiff. Much is dependent on the contingency arrangement entered into by the client with the lawyer and the applicable legislation in the US state in which the action is brought. In most US states, contingency fees are limited to a maximum of 45% of any award received by the client. However, in some US states, the percentage amount of the lawyer's contingency fees can be significantly higher. In the United Kingdom, use of contingency fees allow a lawyer to enter into 2 types of contingency fee arrangement. Conditional fee arrangements, whereby a lawyer can claim a success fee in the case of a successful outcome to the case being brought. However, it is worth underlining that the lawyer remains liable for costs if there is an unsuccessful result. And damages-based agreements, whereby a lawyer can claim an actual percentage of the award in the case of a successful case being brought, but the lawyer remains liable for the costs of the action if there is an unsuccessful outcome. The percentage that the lawyer can claim depends on the type of civil action being brought. I hope you enjoyed this introduction to the business model employed by the Anglo-Saxon law firm.